maintain them in the required format. Quarterly transaction reviews. Audits for the next quarter will be in Judicial District 15, composed of Layton, Brunswick, and Columbus counties, and Judicial District 33, composed of Davidson and Davie counties. Any questions about the report? Great. Have a good meeting.
Thank you, Ann. About our ethics hotline, we'll have Sue.
We answered 1,197 inquiries, and I like to give the top 4 categories of the questions that we get. And for last quarter, the top 4 were conflicts, which is always number 1. Trust accounts was number 2, and that's unusual, but I think the reason for that was because of the bank collapse and also issues with e-filing. So we got a lot more questions about trust accounting. And then confidentiality and advertising. And those are your top 4.
Thank you. All right, Mr. Oden, give us a report on the CLE ethics presentation.
Sure. So we collectively gave 13 different presentations over the past quarter. Of course, this past quarter was the end of the CLE year, I should say the end of the CLE grace period. And so that's usually when we get a little more requests for doing CLE. But just as a reminder to you all in your districts, the organizations you're affiliated with, if you ever 6 hour and people are just looking for a speaker, feel free to give us a call if we can make it work in our schedule, whether by attending by Zoom or in person. We will try our best to accommodate that because we want to be out there and available to everybody. But I also have to point out that one of the presentations was with Professor Ellen Murphy's class in Wake Forest. She has a group of students that were, one, incredibly engaged, but they were the nicest group of students. After I spoke, I think I had 20 different saying thanks for coming by. So good on you for training these students to be very, very nice. That was very good. I don't know if that was extra credit to send an email that you were blind, but that's all.
All right, let's move on to rule amendments, and we're going to talk about a consideration of amendment to Rule 1.8E, conflicts of interests. And so I'm going to let Nicole give us an overview. Oh, Brian.
Nicole is in her voice, so I'm going to try to and I know I'll fail miserably. Rule 1.8E, so you all know that there was a subcommittee formed, I believe it was at the October meeting, to study an amendment put forth by the ABA and the model rules, Model Rule 1.8E, 1.8E, of course, being the rule that prohibits providing financial. The model rule amendment basically provides a new exception that a lawyer that's representing an indigent client pro bono or a lawyer that's representing an indigent client through a legal service organization can provide to a client for basic living expenses. It's generally referred to as a humanitarian exception. As long as certain conditions are met, namely that the lawyer isn't advertising this ability, they aren't trying to collect on any modest gift. It is truly a gift. And also that there's no offer of this gift or basic living expenses as a way to retain or to get the person to retain your services. So the subcommittee formed and took a look at it. This past quarter met in February. Judge Dorothy Hairston Missertle is our chair of that subcommittee. Proposed amendment that is in your materials, and I believe this received unanimous approval. So as you can see in here, just as far as the overall structure of it, this very, very close follows the model rule. There were slight changes really to expand the rule to cover lawyers that represent court-appointed clients, because the prior model rule did not have that particular recognition And as you know, there's that question of, well, if you're representing an indigent client, yes, and it's pro bono, not really. You're getting paid a court-appointed fee, but that person may be, ordered to pay the cost of representation. It gets all murky, and we realize that those individuals are in the exact same situation and be appropriate. So that is I'd say the primary tweak that we made to the model rule to allow these types of modest gifts. But again, the proposed amendment has been. Judge, do you have any other comments?
So I do. I would just start off as I always do, which is thanking you, or really to work with the other subcommittee members as well. And I say that because we're hoping that we're able to push this along today. So I'm speaking in terms of what the end all will be, which is hopefully that would have been our last meeting that we had in March. Even though we have lots of fun in our meetings. But I think the rule and the amendment that you all have seen in your materials is just what we all know to be what our lawyers in North Carolina really are about. We really do want to. A lot of discussion about pro bono and indigent and modest. We had a whole lot of. That's why you see that list there about food, rent, transportation, medicine, and other basic living expenses. We also had a lot of discussion, I'm sure Warren is going to chime in about this, about workers' compensation for lawyers that represent folks in that area and personal injury claims, and that it just pretty much rubber stamps what we know our lawyers already are about in North Carolina. So I really hope that we are able to push this along today.
I see a lot of the other subcommittee members here. Anybody want to comment further? Or certainly if anybody has a motion. To all of you, Judge, Ashley, Mike, Warren, Sydney, I know who's not here, Jack and Stuart, thank you all. So now we're going to move on to pending inquiries, and we're going to go to double billing. Which I'm on the committee, subcommittee, so I can say that with that tone. Overlapping. It's kind of like we went from legal deserts to legal oasis. We learned yesterday. Yeah. So overlapping legal services. And so, Brian, I'm going to let you give us an overview of that.
I think we're all familiar with this particular bill, essentially the question posed. I say reaction. No, we are. The subcommittee really is, and I think Davis can speak to this. The subcommittee is vetting this thing so thoroughly because we realize there's a ripple effect with every single decision, everything that you make, anything that you trying to explain how you arrived at one particular conclusion is going to have an impact on other conclusions. And so because this is something that could have a drastic effect on lawyers and their billing structures, we want to make sure we're kind of took a different approach to the opinion, circulated that to the subcommittee, but that was only circulated last week. And so we, I think we're still looking to hopefully find an answer. Davis, I don't know if it's appropriate to forecast that. I'd like to think we would have something for you all in July. Like I said, fully and trying to get it right. So, Davis, do you have any other comments here?
No, I think Brian's right. I think we are. We may try to squeeze in. Deliver. I think we worked. I mean, this started a year ago when we published this, the inquiry for comment, and at the April meeting, if y'all might remember, there was a lot of people that thought this was a no-brainer, and we just passed it through, and that it was, good as written. And I think that we learned over time that that's not accurate. So I think we're trying to balance three main interests. One, that we have to give faith to lawyers that they're going to do the right thing, and might not have an opinion that might. Some space. It's kind of what the public perception is of us issuing an opinion, of lawyers and our self-regulated body, the state bar issuing an opinion. The question is, how do you? That hasn't been certain. Guidelines and parameters to billing more than straight yes no analysis. So we're always interested in everybody's kind of comments in this committee so we can kind of hone on where we go.
And Davis, you've done a great, exceptional job navigating us through something that 1 minute seems like it's possible. Board. I don't know if any of the other, Jack, Lamar, Bill, if you all have any more.
Bill. Yeah, that has been the part of our conversation. From my understanding, I've talked with a couple of folks, one of our counselors who is in that very scenario, and says that the insurance companies are already cutting our travel rates because they expect that we're doing work while we travel. So that's where it's this interesting thing where we're writing an opinion that is addressing or is attempting to address not just the ethical parameters, but also what is going on in practice and what is acceptable in practice. Not trying to just change things for change's sake. But still, yes, we've looked at that, and I think the current kind of view on that is if you're traveling and you're providing legal services at the same time, that question being, can you charge a travel fee? And what does that travel fee look like? It seems appropriate, certainly, to travel for expenses. I think the subcommittee has no question that of course you travel for expenses of travel. Whether you charge a flat fee for travel as opposed to the hourly billing, perhaps the flat fee is more palatable because when you're charging that hourly fee for travel, which is supposed to be reflective of your inability to do work, but you're able to do work, then you have a question of whether or not that travel fee that's supposedly taking you away from your office is justifiable. And this is the whole thing where suddenly you get into this kind of litany of thoughts and the ripple effects in that regard. And so I think that's the taking into account all the different practice areas, how this plays out has been at the crux of our conversation. I think why we find ourselves arriving at one conclusion, then posing one other scenario and applying that same conclusion to that scenario and realizing, well, that doesn't seem exactly right. So yeah, we're hoping that the final version will properly balance those nuances to allow folks like Davis said. I know Jack has said this in the subcommittee a great deal. Allowing lawyers to do the right thing, to use their own professional judgment in determining what is the appropriate billing structure and so forth. So we want to give guidance, but also enable that freedom to act appropriately and trust that lawyers will act appropriately. So,
Warren?
Has there been any discussion about the interplay about billing for somebody like Craig's firm that has multi-state presence, different rules in different states?
no, we have not taken into account all the different ethics rules.
I think it's a big deal. I think we need to have
Yeah.
a big firm lawyer that has, or two, that has some input, because it would be hard.
Yeah. Well, and I think, my initial reaction, I don't disagree with you, Warren. I'm just kind of torn on our opining on the appropriate application of other states' rules. Maybe
I just mean the practicality of a firm that
Yeah.
bills for 50 different states trying to bill.
right. Well, and that's where they'll have to comply with all the state's rules. But I think that's kind of one of the things that if we were talking in January and even at some of the subcommittee meetings about doing something different, saying that lawyers can, basically, you can double bill. You can bill a full hourly rate for travel while you're also simultaneously billing a full hourly rate for work. That would be different than any other jurisdiction, including the ABA, in terms of offering their opinion. And so that's something that, I believe, Catherine, you had said this at the last meeting, that it just doesn't warm your heart to know that we would be changing the game, so to speak, and going against the conclusions of so many other jurisdictions that have previously looked at that. And to that point, that weighs into our analysis as well. So, yeah, I think, Davis, you summed it up very nicely right there. You thought it was a straightforward issue. It has turned out to not be that, but we hope to have something for you all to review in July.
Any more questions? Not, I certainly will entertain a motion, which would be a motion to return to subcommittee.
So moved.
Thank you. We have a motion to return to subcommittee and second. Any further discussion? All in favor, say aye.
Aye.
All opposed? So just as a reminder, in July we'll be in Asheville, and everyone's going to be much more casually dressed. But if there is a rule in there, I'm going to ask all of you just to set aside 30 minutes and make sure that you read it. I don't know that we will necessarily be ready to publish in July, but we will. There's going to be a lot of commentary. And so I'd like everyone just to take a few minutes, put your feet up, or have your shorts on, read it, so that we can come into that ethics meeting and get as many comments as we can. And maybe be ready, maybe not be ready, depending on how things turn out. All right, next we're going to go to the inquiry for the North Carolina, or inquiry of the North Carolina Dispute Resolution Committee about lawyer mediator drafting terms of a mediation for pro se parties. And Suzanne, I think you're going to give us the overview.
This is an inquiry we received from the Dispute Resolution Commission seeking guidance for lawyer mediators who are dealing with pro se parties. The issue is whether it's permissible for the lawyer to draft an agreement between the two parties setting out the terms of mediation, or whether the lawyer mediator would be violating Rule 1.7 by representing two opposing parties. The DRC wants to encourage lawyers to assist pro se parties in mediation, and they are hoping for guidance on how lawyers can do this without violating the rules of professional conduct. This inquiry went straight to a subcommittee, and during the first meeting, the subcommittee discussed the potential usefulness of an AOC mediation terms form that lawyer mediators could use when they are mediating between pro se parties. Tara Kozlowski, I'm sure that's all right. She's the executive director of the DRC. She participated in our subcommittee meetings, and she agreed to approach the AOC and see if they could start working on a draft mediation terms form, and that was also spearheaded by Gina. So Gina and Tara have been working on getting a draft mediation terms form together. The original inquiry was tabled after we learned that it was a possibility to perhaps have a form for lawyers to use. It's been tabled pending our review or receipt of the form. Tara let us know that the DRC Standards and Advisory Opinions Committee is meeting April 21st, which I believe is tomorrow, and they hope to have a draft form for us to review after that meeting. So the subcommittee plans to meet in early May and hopefully review that form and then decide whether we want to still issue a proposed ethics opinion that discusses that form and explains how it can be used by lawyer mediators when dealing with pro se parties.
Gina, anything else to add?
No, I mean, I think the committee agrees that it's sort of an access to justice issue, and so we need to figure out a way to do it. This seemed like the least restrictive means to make it happen. Not only is the Dispute Resolution Commission interested in helping us, but whatever the North Carolina Bar Association Dispute Resolution Committee is called, they're in on it too. They like it. Everybody thinks it's a good idea. We just got to figure out how to make it happen. So we're letting the people that originally raised the problem, let them try to solve it first, and then weigh in on that. That's where we are.
Sounds good. Anyone else on the subcommittee have anything else to add? All right, if so, I'm happy to entertain a motion to return to subcommittee.
So moved.
Second?
Second.
All right, I have a first and a second on returning that matter to subcommittee. Any further discussion? All in favor say aye.
Aye.
All opposed? Motion passes. Thank you all for getting the AOC moving. That's pretty.
Well, I don't think
Snappy.
we've done that yet. I think we've got a dispute resolution commission moving, and then we're gonna let them try to get the AOC moving. So we're gonna nudge.
A little snowball effect there. Reason we have a rule that or a proposed opinion that was published during last quarter, and since I'm assuming, Brian, you're going to take this since Nicole was.
Yes, I'll give the overview. So 2023, or proposed 2023 FEO2 deals with an issue about putting a confidentiality clause in a settlement agreement that really impacts, not just constricts, a lawyer's right to practice. The opinion was published this past quarter. The opinion is in your materials. And the opinion concludes that essentially if a settlement agreement contains a confidentiality clause that restricts a lawyer's ability to disclose publicly available information, that violates Rule 5.6. The particular scenario was that there was a restriction in a settlement agreement that would prevent a lawyer from discussing any aspect, including any public aspect of the case, and the case being one that produced precedent, that produced law for a particular practice area. And the confidentiality clause effectively would take the lawyer, the plaintiff's lawyer, out of the practice. It would restrict that person's ability to actually represent anybody in the future, because they would be under this agreement to not speak about anything in the case, including a published Court of Appeals opinion. So the opinion draws the conclusion that violates Rule 5.6, that a lawyer cannot enter into that type of agreement. We received a couple of comments. You see there's a memo in your materials, as well as an email that we did receive, where folks wrote in just saying that they understood the general premise, but they were reading the opinion to be perhaps broader than the subcommittee intended. Questioning, exactly how broad can this confidentiality clause be? Understanding that particular scenario of restricting a lawyer's ability to talk about a published appellate court case is kind of ridiculous. But when you apply that conclusion to other aspects of the case, like the underlying facts of the case, is it still appropriate? It's not necessarily a restriction on the lawyer's right to practice, but is that type of confidentiality agreement still appropriate under the rules and really under this opinion? And so staff reviewed those comments and concluded or would recommend that this be returned to subcommittee to kind of review the opinion, review the language in light of the comments, and see if there are any tweaks that need to be made to ensure that the opinion is really addressing what the opinion was intended to address, as opposed to perhaps encompassing a lot more that was not intended. So it'd be our recommendation to return it to subcommittee for further study.
All right, Chair Evan, you have more you want to add?
Just a little bit. I thought the comments for a change were thoughtful and on point, which is sometimes unusual, but they were thought-provoking and meaningful. So I agree. I emailed Nicole that I concur with staff's recommendation that we return this back to subcommittee so that we can clarify what appeared to be a real simple matter is now turned into something a little more complex, but something we can solve with, I think, one more meeting.
I think maybe that's our byline. The ethics committee, we take simple things and turn them into complex rabbit holes. So we've got some other members here. Anyone else want to comment on the comments or possibly the recommendation, which is essentially to return to subcommittee? If not, I certainly will entertain that motion.
So moved.
Do I have a second? So the motion is return that issue to subcommittee. I have a first and a second. Any further discussion? All in favor, say aye.
Aye.
All opposed? All right, now we got the new stuff, which is not as exciting as the doctor fight we had last time.
No.
So the first one we're going to talk about is the conditional delivery of escrow funds for repairs. Brian, you going to talk about this
I'll tee
issue?
I'll tee this up. That's all right with you. Okay. Not trying to just steal Nicole's thunder today. Inquiry of Perry. We received this inquiry over the past quarter. And you'll see the original inquiries in the materials as well as a proposed draft opinion. The inquiry essentially addresses this question of what can a lawyer do with entrusted funds delivered in a residential to perhaps like a roofing contractor. That's the scenario that we have here. Upon completion of work, the inquiry that was submitted to us was that buyer and seller have an arrangement to have this home sale, but there's roofing repairs that need to be done, and the seller says, well, I just need to get on with closing, I need to move on with this, how about you just take $10,000 out of my proceeds and you give it to the roofing contractor once they finish their work, but the roofing contractor cannot complete the work probably for 4 weeks after closing. So they're asking, well, how do we do funds and then deliver them to the roofing contractor? The lawyer has agreed to do that and act as a fiduciary, but they want to charge a nominal fee for that service. And so the parties came to the lawyer and said, well, how about a different arrangement? What if you just cut the check for the roofing contractor and give those funds to the realtor? The real estate agent, and they'll deliver it to the roofing contractor. Or maybe you just give it to, you cut the check so it's out of your account. Either you hold on to a certified check or you give the certified check to, you don't have to pay your fee for holding the funds and preserving them. And so the opinion goes through that analysis and basically draws the conclusion that you can't make this conditional delivery of entrusted funds. They had proposed was essentially to have the lawyer delegate their responsibility to safeguard those entrusted funds to someone else. They're now giving the check to the real estate agent, even though it's their responsibility to make sure that it goes to the source, to the person that was instructed by their client. And so, basically draws that conclusion that no, lawyer, you should just hold on to funds until the work is complete and the condition can actually provide the funds to the person, the third party, as directed by your client. Again, the opinion is in your materials, and I think speaks. It's one of those things that we drafted. Think we've arrived at the right conclusion. There may be some nuances, and I think that's where some of the folks that have been to weigh in perhaps would love to get some feedback and see where you all would like to take this.
So as a reminder, if your name is right, well, it means you were supposed to read and report. So I feel sorry for Tom, Craig, and Amy because I hope one of them were able to do that. Do you have any comments about the inquiry and the proposed rule? Anything for discussion?
Well, you're delegated fiduciary duty to a third party, not even a lawyer, it's a realtor, governed by different rules.
Right.
I mean, it's such a sacred responsibility to have these trust funds and sort of washing your hands of it. So I don't think it's appropriate.
Amy?
I think the answer is right. I am not yet convinced we need an opinion on this. This, to me, feels like entrusted funds which we have rules and opinions about. I don't think this is very factually specific, which is how the inquiry. They're going to be holding a check for repairs large enough to warrant an opinion that could create confusion to what I think is already a very simple, straightforward rule.
That's great.
Thank you. Craig, anything else?
Yeah, I think the principle is absolutely spot on. I think if you see control, you've got no ability to kind of make sure that things happen the way.
Yes, Gina.
At the risk of throwing a spitball, this was a little bit related to having billing issue. What legal service is being performed that can be billed for holding checks and dispersing them at various times? Like, what? Because I want that. What is that? That's not legal. Like, it's some sort of ancillary Sure, I guess.
Yeah.
But I think that was my, like, how do you think you get to charge for writing a check next week as opposed to this week?
Yeah, I
What
think
is that about?
that's generally, I guess we generally look at it as an escrow agent. You know, that you as a lawyer, you're being retained and asked to hold these funds because you were the lawyer and you are the escrow agent in this particular circumstance. And so we have previously said that lawyers can charge some nominal fee to provide that type of service as a fiduciary.
Because it's past the closing date.
Because it's past the
Outside
closing, it's beyond the scope of the original, I don't want to say like the original legal services, but especially in this scenario, the closing is when everything is supposed to be dispersed, so you're asking something extra of the lawyer to hold on to safeguard those funds. And those roofing repairs, for this one, maybe they get done in 4 weeks, maybe they get done in 4 months, because they hit who knows what else.
So the escrow agent fee is showing up on the HUD or whatever you call it, self-statement now.
It should. Well, I guess maybe, no, wait, excuse me. The escrow fee should be a separate thing outside of the closing. Take that back. Yeah, it's not supposed to show up on
So
that.
that's my point. These
Yeah.
closing lawyers don't have contracts with their clients.
Presumably, there would be a contract of, you want me
In
to.
this particular scenario, they're asking for, the lawyer's asking for it to serve as the escrow agent, so he prepares an escrow agreement.
Okay.
Yeah.
And in that agreement, he
That's the-
includes a fee to serve as the escrow agent and disperse those funds later after closing, whenever the roofing repairs are done.
Okay. All right. Got it now.
If I can weigh in, just, Gina and I run into this all the time, it's the reason that so many closing attorneys are pushing these title insurance companies to serve as the escrow agent, because some people don't like being in this role of being the money manager once the legal services are concluded, or even prior to closing. But I mean, it's a real thing that happens in these situations. This isn't unusual. I don't like the fee, but I think they're doing it to compete with the companies that will serve as an escrow agent otherwise.
Got it.
And I'll quick comment on what Amy said about the necessity of an opinion. I think that's a very fair point. We put this on the agenda because of a couple of reasons. One, Mr. Perry wanted an opinion from the ethics committee. And two, that when we looked at the prior opinions, there wasn't anything that was directly on point with this, although I think we may all be in agreement that our current opinions and rules provide the answer. But nevertheless, this is one of those things that we wanted to put before you all to see if you wanted an opinion, but we can also go with a non-published product. It can be unpublished product, an ethics advisory letter. There's ethics decisions that do get approved by the council, and they become kind of not necessarily part of our formal ethics opinion canon, but that they are still reviewed by the full council before dissemination to the inquiring party. So I think that could be potentially part of the subcommittee discussion. I think it'd be beneficial for if we have a feeling that this opinion basically gets it all right and I don't have any changes, then we can have a discussion about what format it should take, and we can have that discussion right now. But if there's anything for those that have looked at it and you're thinking, I think maybe it could address this or clarify this point, then it'd be appropriate to have that discussion in subcommittee where you can also discuss the product that the ethics committee provides to Mr. Perry. So perhaps we start with the question of just, is there anything that needs to be tweaked in this opinion, or do we all feel like, well, the analysis is what it is and it gets it right? We can just talk about how we want to transmit it.
Maybe let's do it this way. Does anyone who's read the opinion think that it's wrong? Okay. Does anybody who's read the opinion think that there's something that maybe needs to be refined a little bit?
No, I think we just do format.
Okay.
Yeah.
So it looks like the opinion's good. So the question is format, and our options are
An ethics advisory, which is a letter directly to the inquiring party. It's communicated to the party. It's kept on file here. It does not get published. It's essentially signed by the chair of the ethics committee with the approval of the full committee. But it is something that the lawyer is allowed to rely upon, and it's essentially kind of a more formal version of what we provide when we give advice via email. to lawyers.
If another lawyer has an inquiry similar to that 3
Yes.
years from now, you share that letter with him?
Yeah, this will be a public document still, but it's something that I'd say more so than, necessarily, we can share it, but we usually just rely upon it. Internally, we'll utilize that analysis again. But yes, it's something that we keep on file for future use and guidance by staff. The other options would be an ethics decision. Ethics decision basically looks like an ethics opinion, like a formal ethics opinion, but it does not get published to the full profession because it's one of those situations where you think of it as a kind of a sufficiently nuanced area that it's not really beneficial to the full profession to see this and have this available. But the ethics decision goes to the council. It gets published to the council over the next quarter. It has to be approved by the council before it's adopted. And I guess you could say that's a bit more of a formal version. We're increasing our level of formality. Kind of like, in grievance, you go from admonition, reprimand, censure. It increases in significance. This is increasing the significance. Ethics advisory, ethics decision, and then formal ethics opinion. But the ethics decision, the benefit of that is that it goes to the full council, and you have the full council's blessing on this particular opinion. Candidly, I feel like ethics decisions are quite infrequent. It's mostly the informal advice that we give, ethics advisories, or formal ethics opinions, but it is an option. And of course, the formal ethics opinion is the last option, which you all are very familiar with.
So it kind of sounds like we're in between ethics advisory and opinion. Maybe not. Is anybody like me leaning towards
Anybody has-
ethics advisory letter?
Is there a motion?
I move
Oh,
that-
No, I'm sorry.
I move that we issue an ethics advisory.
Second.
All right, the motion is to take the opinion or the draft that's in your materials and use that as an ethics advisory letter. Any more discussion? All in favor, say aye.
Aye.
Any who oppose? Ethics advisory. Next, we have an inquiry regarding fee agreement requiring payment of estate planning lawyers' future legal services. And so Suzanne, will you talk about that?
Yeah, I think this is gonna be one that we're gonna have a little bit more discussion on. Staff went back and forth on this ourselves. So the draft that you have in your agenda is just a starting point for discussion, probably. This is an inquiry we received pertaining to fee agreements with estate planning clients. A law firm began seeing an increase in the number of their estate planning lawyers being required to participate in caveat proceedings, and the law firm is looking for ways to recoup these lawyers' billable hours. The firm is considering including a provision in their fee agreements that would require the client's estate to reimburse the firm for any legal fees and expenses incurred after the client's death relating to the estate plan. The particular provision that they're looking at would require the client's estate to reimburse the law firm if a lawyer is deposed, called to testify, or required to respond to discovery concerning any aspect of the client's estate plan. The proposed provision also makes the estate responsible for any costs the firm incurs when participating in any proceeding. And I should have also said that the hourly rate charged to the estate would be the lawyer's hourly rate in the future at the time that they're called to participate in the proceeding. The provision states that it's binding on the estate planning client as well as the client's heirs and beneficiaries. And the issue is whether this type of provision is permissible under the rules of professional conduct. And we looked at this a couple different ways. On the one hand, if a lawyer does everything right, but yet some documents are still challenged, it seems reasonable that that lawyer should be able to charge for their time in participating in any challenge. On the other hand, if a lawyer has not done such a great job, and because of that, there is a challenge, it doesn't seem reasonable that that lawyer should recoup legal fees because his own work was subpar. So we tried to come out with tried to come down the middle a little bit, but like this is gonna need a lot more refining. But the opinion concludes that this type of provision is not permissible because the provision does not comply with the requirements set out in either Rule 1.5A or 1.5B. The opinion discusses the two prohibitions that are set out in Rule 1.5A, and that is that a lawyer cannot make an agreement for an illegal fee or for a clearly excessive fee. The opinion notes that the legality of the provision is outside the purview of the Ethics Committee, but that the law firm has a duty to investigate whether such a provision would be legal and enforceable, and if they determine that it's not, then they cannot include it in the fee agreement. The opinion then goes on to discuss the second prohibition in Rule 1.5A, which is that a lawyer cannot charge a clearly excessive fee. And the opinion talks about the broadness of the provision and the fact that there is no exclusion for legal services that are made necessary due to the lawyer's poor drafting. And it concludes that to charge the client's estate for legal services made necessary by a lawyer's own conduct would be clearly excessive. The opinion then looks at Rule 1.5B, which requires a lawyer to explain to a client the nature of the legal services being rendered, as well as the basis, rate, and total amount of the fee. And the opinion concludes that this provision does not meet those requirements because it is not specific enough. The language in the provision would make the client's estate responsible for an unlimited amount of costs and fees based on a yet-to-be-determined hourly rate for legal services relating to any aspect of the client's estate plan. And the opinion concludes that it's not adequately specific and doesn't comply with Rule 1.5B. The opinion notes that a lawyer in this circumstances, there's nothing prohibiting a lawyer to seek court approval from the estate for legal services for their expenses and time spent as a witness, just like any other witness or in a will caveat proceeding. The opinion goes on to state that although this particular provision is not permissible, it's not to say that there would not be some provision that would be permissible, and this is where we'll be looking for subcommittee input. I think when a lawyer is dealing with a complicated estate plan or one where they can foresee that there's likely to be challenges, maybe because it's an elderly client who has their wherewithal, but because they're 95 years old, it's likely that there might be a challenge. It would be appropriate in that circumstance to include a provision, but it needs to be a lot more specific than the one that we looked at here. Specifically, the law firm is going to have to look at the legality of the provision. We feel like there needs to be exclusions for incompetence or negligence, and that it just needs to be more specific.
Right, so we have Takia, Wade, and Stacy. We're on tap to read this. Takia?
I actually like the opinion. I think that the proposed, and whatever you want to call it, that they were trying to put into their agreement was just ridiculous on its face, right? Like, you're not going to be able to, bind parties in perpetuity. You're not going to be able to do that. And so, like I said, I really like the opinion. I think there probably are some weeds we can get into as far as more specifics, but I do like that it addressed that you can't do this, but there may be some other things that you can do, and maybe we can look into those things generally, not specifically as to whether they're the legality of it or whether it's permissible, but just to try to give lawyers an idea of what they can do. Like I said, I like it.
Moving down the line, Wade?
I like the opinion as well. The only thing I didn't like about it was the very last paragraph, because that seems to me to be a bit vague. For example, I don't see anything wrong with a client contracting with an attorney to pay a fee with a cap if it's necessary for the attorney to go in and testify about the work product. Or you could flat fee it, or you could specify the hourly rate. And I think that, I haven't researched it, but I think that would be fine in the state. I think if it's an obligation that's made by the decedent, it's perfectly foreseeable that something like that could happen. And it would give the attorney the opportunity to have some recompense from the estate and have them be able to make a claim against this. Now, if it's a malpractice action against the attorney because the attorney allowed an incompetent person to make a will, that's a whole different ballgame. That's not a challenge to the will itself. That's a claim against the attorney. But we're in a time now where we've got people with Parkinson's disease and Alzheimer's, and there's a real question about capacity. In my former life, I've tried these cases, these real caveat cases, and they're difficult. And they do absorb a lot of time by the people, not just the lawyers, but sometimes you subpoena the people that folks who are put in that position to make a claim against the estate. And if you will sort of take care of it, because you will have to, anybody that's in this line of work will have to charge more because you can anticipate what's going to happen down the road. So I would hope we could give lawyers some more specific ideas about how they could create a transparent contractual fee agreement with their client that might be enforceable against the estate.
Stacy?
I would agree, and I've had this actually come up in the past year, and it was in a litigation matter, not caveat, just a separate litigation matter. And I did find the attorney somewhat reluctant because he's not being paid. So I would agree with both of the comments. I think that we could tailor it such that there would be some type of compensation, so it wouldn't show the market.
Gina?
Same spitball, different opinion, but what we're talking about is lawyers being paid to be fact witnesses.
Yeah.
As opposed to expert witnesses, as opposed to lawyers. So talk about a slippery slope.
Yep.
So I think we need to tackle that specifically and say, if this happens, you are not being a lawyer. You are testifying as a fact witness about the legal services you perform. But here's why we think you can bill for it,
right,
and make it different than every other circumstance where lawyers testify as fact witnesses and we don't get paid.
Absolutely.
And I would also exclude a negligent situation, and that's not right.
Right.
I think the difference, I dodged the spitball. But I think the difference is there's a contract. Right? If the person's agreeing to it. And so they're agreeing that the lawyer being the fact witness and taking the necessary notes and doing the necessary things to be a good fact witness is something they're willing to.
Is a legal service.
Right.
The client is agreeing that you testifying later as a fact witness is legal service.
Right.
Warren?
I look at this like it's a less drastic thing than a testator right now is allowed to put into their will. If anybody challenges this will that's due to take under this will, they can't. If they don't win, they don't take under the will. Period. They can get that right amount and put that in the will. So this is even less drastic. I could put this into my will to say if anybody opposes my attorney and forces him to do all this stuff, you're going to be taken away from the estate. And I'm trying to dissuade you from challenging this. And it's less drastic than actually cutting them out. And so to me, why couldn't you just put this in the engagement agreement? I don't know, but I do think it needs to be thought about, and I do think the will caveat situation is pretty unique. I really do. We're not going to get stuff from personal injury lawyers saying, putting into their agreement, their contingent fee agreements that they can get paid their hourly rate. We're not going to get that. This is a thing that's recurring. It's going to recur more and more because the aging population, these old people, myself included, coming up, it's going to be something that comes up. I do want to acknowledge that my colleague Will Gravy is the one that's in this inquiry, and it's because we're getting asked this a lot. People are getting deposed, or getting, and not related to malpractice, just related to the other circumstances of the will, and the drafting of the will, and the execution of the will. So it is it's something that's coming up, and it's going to keep coming up. So I agree with definitive subject.
Yes, Ashley.
Just to piggyback on that, so Lawyers Mutual used to hire me to represent their insureds in these matters, and they are, yeah. They are, they are, it's very burdensome for the lawyers who are involved and requires a lot of time from them to respond to the subpoenas, get ready for the depositions. It really is a significant issue for them.
A situation that these fees would have to be court approved. I know in certain contexts you have court approval, and you charge attorney's fees and that. So it's in there. So I think that might be something the subcommittee discusses, is how does this bump into, or if it bumps into the court approval process.
It sounds like to the inquiry we have a great start. Some tweaking needs to occur, which probably sounds like it needs to be sent to subcommittee. I have a motion.
I've got a question.
Yes, Todd.
This is perhaps about the scope of our work. To me, this is a very limited, discrete inquiry. My view was we answered it very, very clearly up until we got to the last paragraph. And the last paragraph, I guess, perhaps to use a legal analogy, might be dicta, because we're addressing something that's going to happen in the future, whereas we addressed a very specific question that we were asked. And so I love the opinion of until I got to the last paragraph. So I think we need to think long and hard about that, because I think there are issues of enforceability. I think you hit in the second paragraph or so, there's a concept of vagueness or indefiniteness, and we're talking, I think I recall some contract principles that you can't agree to, something that might be void for indefiniteness or vagueness. And so you got the enforceability issue, but my question was, is it, and maybe Brian, you can answer this, or Suzanne, if we get a very specific inquiry like we got from Gravy, how often do we need to go farther than that? Because we answered the question, and I think the answer is correct. Now we're getting ready to add another paragraph that might get on that slippery slope. So that's the question as to what's our general approach in terms of the scope of what we do.
I mean, that's a great point, and I think the reason that we didn't just stop it is because we really felt for the lawyers who are spending all this time, and we really wanted to give them some guidance. But you're absolutely right. In responding to the inquiry, we could just stop it before that last paragraph, and that would answer the question, and it would be short and sweet. But we just were really torn about what the answer should be regarding these types of provisions, because we just.
Well, and I think understanding, to Warren's point, these are coming up a lot, and I think everybody's echoed, like, these take up a lot of time. So if we answer just straight no to this one, are we going to next get the question of, so then what can we do? And so maybe that's the launching point. But that's where we get into, like, to your point, we're addressing something that is in the future that might happen. So I think these are all great points for discussion in subcommittee to try to figure out exactly the scope of the opinion as well as the specifics of the content.
Warren?
I can tell you that, speaking for Will, because I talked to him about this before, the provision in there, Todd, that he put was more, I found this somewhere when I was looking on this issue. And so I threw it in there just for you to consider. But I think the bigger picture question is whether lawyers can, and if so, how can they do this, provide for this, whether it's through an engagement agreement or something else. But I think, if we could give them any guidance on that, one way or the other, that would be great.
Well, I go back to the old advisory opinion concept. It might be good for us. And also I'm thinking about it because it's a different context, but my firm we draft a lot of documents, a lot of money. And they go bad and we get sued. And the client, or we ask to be witnesses or provide documents, and the client doesn't say, okay, we're going to pay you for doing additional work on this case. When you draft the document and it's now being challenged, I get the point. And there are ways to do that. Can we limit it just to state issues? If you're going to draft something, must it be broader to include something other than a real contest issue, which I don't do. But I think we think about whether we can draft an opinion that is going to apply to future scenarios other than the will context, if we're going to try to provide some opinion or guidance about what we might do in the future if a challenge arises. So I think we got to be careful when we get on these slopes and whether we can limit it to will, like Warren mentioned, or whether it's going to apply, or whether we're going to offer advice that applies not only to this specific context, but other contexts, because if you answer it for one, then it arises in another, then I might want to follow it in my non-will context.
Right.
It's got to be careful. I just offer that for consideration.
Well, I think from a process standpoint, once we get the opinion, do we want it to be an opinion, an ethics decision, an ethics advisory? That'll sort of be the next tier of analysis. But I mean, you've hit our slogan, right? We'll take the simple and make it complex. So I think that this will be something for the subcommittee to dig into. And you brought up excellent points about how far can it go outside of the will context, and do we want to ask a question that has specifically not been answered, or answer a question that's not been asked. So, anything else?
I ask a question. This may be, I can talk about Warren. I had a question about this. We can talk about it later. I'm sorry, go ahead.
That's okay, Todd. I already discovered that I can put you on the subcommittee.
Officers are members of the council.
All right.
Shut up from now on.
That was not my intention. Keep it simple. So I think that it seems that the temperature is we need to send it to subcommittee, but I will need someone to make that motion. First and a second. Any further discussion? All in favor say aye. Aye. All who oppose? All right, I will spend some time in subcommittee.
Yeah, I shouldn't be. I would imagine we can do pretty quickly.
Okay.
Unless anybody wants to.
Okay.
Yeah, let's just go.
So we're almost at the end. We're just going to sort of push through. So our next inquiry is about the installation of a third-party self-service kiosk in a lawyer's office and inclusion of a lawyer in a third party's advertising efforts. So Brian, you want to tell us about this kiosk?
Yeah, so the first task may be creating a better title for this one, but this one was just a wide-ranging sort of inquiry. It's once again a rather simple inquiry. That's going to be complex. Lawyer was asked if are approached by a company to install ignition lock or an ignition lock service kiosk in their law office. The thought from the company is that you have a DWI practice and you have a lot of clients who could use our services. So can we just put this kiosk, really small thing, we can either rent the space from you, or maybe we can make an arrangement where you get a referral fee every time one of your clients signs up for our service. And so this is hitting on the issue of law-related services. And the general notion that yes, lawyers can offer law-related services. Sometimes they can provide that. We have opinions that discuss lawyers that offer accounting services or perhaps financial services, like financial investment, things of that nature. But this one is kind of a slightly different animal because you've got this third-party company coming in. It's related to your practice. It very well may benefit your clients. So if your clients having to hunt down, how do I sign up for this ignition lock service? I can just do it right here. And so rent or a referral fee, really, that you are receiving some sort of financial benefit from the existence of this kiosk in your office. And that is doing business with a company and lawyers benefiting from clients' business with the company. So it does implicate 1.8A with that particular conflict rule. But it brings up conflict of interest issues. It also, the opinion goes through the process of just, recognizing that can a lawyer recommend those services? Yes, as long as those services really are in the interest of the client, the best interest of the client, and that lawyer is fully about the relationship that he or and that essentially the lawyer gets the client's informed consent to the conflict of interest that exists in recommending those particular services through the kiosk that's in his lobby. The opinion goes on to address a last inquiry about the company wanting to include lawyer in their advertising, namely online advertising, Google keywords, Google AdWords, where if somebody searches for ignition lock services, lawyers. Our new rule on intermediary organization, Rule 7.4, which I know everyone is just crazy familiar with, right? But we amended the advertising rules a couple of years ago, and 7.4 is a new rule. As an aside, just in case anybody's aware or was wondering, yes, it has been copied. Tennessee actually saw it a year ago. So good job, advertising team. But nevertheless, it implicates that relationship. When you have an organization that's facilitating a company is not really engaging in some sort of improper solicitation. So the opinion goes through all of those different things. Curious to hear some feedback on where the committee would like to take it.
Kevin, Jay, Ellen, any specific comments? Yes.
Having read it, first it reminded me a lot of the subcommittee we had on the PI chiropractor case. And the list between the offices. It appears correct in my reading. The employee, if Monotech, for instance, has one kiosk in your town and it's in that attorney's office, they must be the most qualified attorney in town. I want to discuss about the initial opinion.
Yeah, I think the referral is directly on point. I'm not quite 5.4. I don't think this is a clean fit for 5.7.
Yeah.
I'm troubled by the conflicts of interest and the specific interest conflict. How the lawyer is paying rent? Is it how the lawyer, does it have anything to do with how many people use it? Is it a 5.7, I don't necessarily see this as fitting A1 or A2.
Okay.
Even though I think it needs to fit the place,
Yeah.
right? This may be the place.
Anything else, Jay?
No, I don't really have a problem with the opinion. I agree with both their comments. I think so. Regularly, I hadn't thought about. But I'll say, I mean, for years and years, I've been referring people to assessment services and interlock services, and I never thought about asking for a referral fee, or even thought I could, frankly. So,
Right.
I mean, this is something that really crossed my mind that I could either rent, putting that in the office is a little bit different from getting a referral fee. And once you bring it, to Bill's point too, I mean, a lot of times these interlock companies have problems with their devices, and then we get involved. Once you bring it up, you talk about it more. Thanks, Bill.
Love it, love it.
There's a potential conflict of interest that happens more than you would think, where there's a positive reading on the condition interlock device, on the Scram device that you embrace it, and it can have real consequences to your licensure. Invoice it can be used for terms and conditions of bond in criminal cases, family law cases, and we occasionally call to challenge those at DMV hearings, bond hearings, and so now your rentee client is now the witness against your client who you refer that case. It's not unusual to refer. There are only 3 interlock companies in the state that are approved by statute. We're going to one. But I guess the attorney would have to recuse themselves or withdraw from representation on such. But it happens more than, it's a big, if you lose your license,
They're approved by, they're all approved by statute, is that what you said? They're all approved by statute?
there are only 3 providers
But you-
approved by statute on the ignition interlock device. The device for the Scram bracelet is a different process, but there are a limited number of companies that offer that device.
Good point. Evan?
This gives me some real heartburn, the fact that somebody's paying rent to a lawyer and or giving them a referral fee is just, I think, the camel's nose under the tent.
We're definitely have that in the minutes right there.
The camel's
nose under the tent.
Camel's gonna be in the
And a little
tent.
picture.
I get it.
Yeah.
I get it.
I mean, I don't want to single out personal injury lawyers and people that do, auto repair, chiropractors and so forth, but I've appeared enough in front of the chiropractic board to know that there's all kinds of, ways that there are to advertise, referral fees, pay rent, and all of it gives me heartburn. And this gives me a lot of heartburn. Bill Powers is, setting up and putting a big kiosk and a sign on his office about Monotech or Scram or this or that, and then, Scram is then able to use your name, image, or likeness, in what they do. It turns into just
That's a legal term for art. Well, that's when we looked at this, and all that. And so it was, I think that's where we were just very curious, and I think it's very enlightening to hear your immediate feedback. And think that'd be some great discussions in subcommittee.
Ryan? I mean, I think it's arguable that it's just a 1.7B personal interest problem, personal interest conflict problem because of the rent without having to go through a law-related service.
Yeah.
I don't know how to think about that.
Yeah,
but
that's
not addressing the referral fee, but in terms of the habit paying the rent.
right.
Yes.
What Evan calls heartburn, those of you who've been on here with me for a while now, I have like the ick factor. And I've used the word icky in this room on more than one occasion, and that's the vibe I have from this. Where is the line between law-related services? And this is talking about slippery slopes. This is a big one we're going down. And my immediate comment to Warren, which is far afield for most of you, is we don't let closing attorneys be title agents, but they get their clients' title insurance policies, which seems to be far more interconnected with less risk. If we're protecting the public, I'm struggling here. I'm struggling to see how the self-interest under 1.7 doesn't outweigh any benefit to the public by allowing this.
That's a great point.
Lots of, what was the rest of that quote? We looked it up. It's if the camel's nose is under the tent.
I
the
sent
rest
you a
of-
picture. The rest of the camel will
Yeah,
follow.
yeah, the rest of the stinky camel will follow. That's what it says. So-
Of the camel's nose under the tent.
Ah,
That's what he did.
That's it. That's it. Exactly right.
Yeah.
YouTube appreciates that.
We listed this live stream as not appropriate for kids, so
That's all right.
we're fine.
The term of the heart. So definitely needs to go to subcommittee. Can I have that motion? Second?
Second.
Any further discussion about sending this issue to subcommittee? All in favor, say aye.
Aye.
All opposed? All right, we'll go to subcommittee. And so the last thing we're going to talk about is we published proposed 2023 formal ethics opinion 1 about the sale of a law practice and proper handling of aged client files. We received 0 comments just because it was so wonderful. And so the next logistic step is that it would be sent to the council for adoption, correct?
Yes.
And so that would be the motion that's needed.
So moved. Second.
So for that opinion, we have a first and second to send that formal ethics opinion to council for approval. Any further discussion? All in favor?
Aye.
Any who oppose? All right, that'll be sent to the council. Jack, you had your mouth open like you were going to say something.
I was just going to support, what Amy said about the ick factor. I mean, when I first read this last night, all I could think of was, yeah, stick that one between the ATM and the cheap cologne vending machine. That's all I had.
And on that note,